counsel is Brian Sia, and we represent the petitioners, Monica and Maria Elena Quispe. Your Excellency, this is a case about the Quispe sisters, two young women from the indigenous community of Wami, Naira, who were detained by the Special Military Base, or SMB, in control of their province when they were only 12 and 15 years old. These soldiers were sent to Naira to maintain control over the area and to fight crime. Instead, for 1 month in March 1992, they took the Quispes away from their homes and detained them on accusations of involvement with terrorist activities. The Quispes were never brought before any judicial authority. For 1 month, Your Excellency, the same soldiers brutally violated the Quispes' essential human rights, first by repeatedly using them as domestic labor and then as targets for their sexual depravity. The fact that these men have been protected from prosecution by a mere lapse of the domestic limitation period is both a violation of Naira's treaty obligations and a travesty of justice. Your Excellencies, my submissions will argue the following. Number 1, that Naira is in breach of the American Convention of Human Rights, or ACHR obligations, to the petitioners regarding the violations committed in 1992. Number 2, that Naira's declaration of a state of emergency does not excuse the aforementioned violations. My co-counsel will argue that under the state's general duty to ensure free and full exercise of human rights to all persons, number 1, the fact that the accused persons have not been prosecuted due to the domestic limitation period is in itself a violation of both the ACHR and the Convention of Bellum do Para, and number 2, that Naira's failure to prevent and investigate the domestic abuse suffered by Maria Quispe in 2014 is also a violation under the same conventions. Moving to our first submission, the thesis for our first substantive point is as follows. In A, repeatedly raping and gang raping the Quispes. B, detaining the Quispes on mere suspicions of being involved in the Freedom Brigade's activities. And C, forcing the Quispes to cook, clean, and do laundry in the Wami SMB during their detention. The SMB soldiers cruelly and deliberately violated the Quispes' human rights. Accordingly, these violations undertaken by state agents in their official capacities can be attributed to the state of Naira.
Were they a state at the time of the violations?
Your Excellency,
Is there an issue there?
On the facts, it appears as though they were a state during the time of violation.
Okay.
At the material time, Your Excellency, we also want to highlight that there are 3 categories of violations.
Why are we not dealing with this under the domestic law? Why would it be a human rights argument as opposed to under domestic law?
Your Excellency, we submit it will be a human rights argument because the human rights of the Quispes have been violated, and under the ACHR, Naira has made promises to protect these very human rights.
Okay.
Moving then to the first category regarding the sexual abuse, we submit that the repeated rape and gang rape of the Quispes is a violation of their rights to personal integrity of a physical, mental, and moral nature under Article 5.1, as well as their freedom from torture under Article 5.2. Under Article 27.2, we note that these rights are non-derogable. While Article 5 consists several gradations and embraces treatment ranging from torture to cruel, inhuman, and degrading punishment, the petitioners submit that the rape and gang rape in question constitutes torture under Article 5.2 because the repeated assaults were firstly intentional acts, secondly they caused the Quispes severe physical and mental suffering, and number 3, they were committed with the purpose of criminal investigation as a means of intimidation, as personal punishment or penalty or for any other purposes.
How are these acts of the state as opposed to the acts of the individual?
Your Excellency, we will argue that these are acts of the state because they are attributable to the state, considering the soldiers were state agents and they were acting in their capacity as state agents when they undertook these acts. This was established in Article 4 of the Articles of State Responsibility and Wrongful Acts.
Is there a need for there to be some kind of, a consistent recognition that this is a matter of state policy before the state can actually be found to be liable for it, or is it just a question of, I mean, look, I don't see that anyone is going to argue that these are not breaches of the American Convention on Human Rights. I think it's quite clear, and I think quite egregious for anyone to make the argument that repeated rape and torture and so on are not breaches of human rights conventions. It's just a question of whether we're talking about a group of rogue agents, or whether there's a need for there to be a proof that this is a matter of state policy or the practice of the state and so on. Because if the question then is about the failure to prosecute, then that appears to be something that would be dealt with by your co-agent, right? So what really is the issue here? I mean, is it really going to be an issue that, rape and so on is actually permissible?
Well, Your Excellency, regarding the concern about whether there was a consistent recognition of these acts, on the facts of the case, there doesn't seem to be any evidence that these were rogue agents or that it was just one soldier in question who was doing this. Rather, we would submit that on the facts of the case, the soldiers in question were clearly undertaking these acts in their official capacity, even if they did act outside the sphere of their authority, or they may have violated the internal law of the state. And as this court has set out in Velasquez, Honduras, a state is responsible for the acts of its agents that have been undertaken in this official capacity, regardless of violations of internal law.
Where is the evidence that these were actions that were taken by them as agents? So the only reason why we think that they were violated as an act of state is because at paragraph 28 it actually says that we can't have any regard to the abuses against the population as a whole, so we can only talk about Monica and Maria. And it says that they were very young and they were both repeatedly raped, many times gang raped by the soldiers, right? And these are the soldiers from the SNB, right? So where does it actually indicate that this was like a matter of state policy rather than sort of poor control over these individuals? I mean, how does it actually arise to the level where the state itself has committed the breach?
Well, Your Excellency, we would submit that regardless of whether this was a matter of state policy or whether it was just poor control and negligence on the part of the state should still be liable for these acts, considering they were committed by state agents, and they were only committed because the state elevated these agents to the point and to the opportunity where they were able to commit such atrocities.
Doesn't that mean that every time like a prisoner is raped by a prison officer, that the state is liable, despite all the measures that are put in place?
Yes, Your Excellency, we would submit that.
Is that really the way it should be considered? Because here what I'm seeing also is that, there are gender-based violence units and so on, and it appears that there is sort of a concerted effort on the part of the state to actually manage, right, discrimination against women and so on and so forth, right?
Yes, Your Excellency, we would concede that there is this concerted effort on the part of the state to manage this discrimination against women. But we would also like to point out that these were measures that were taken quite recently, whereas the SMB issues in question occurred over 26 years ago.
Mm-hmm.
So,
isn't there also a danger in looking at the legality of such actions so many years after they have occurred? If there was such an egregious sort of breach, surely these are things that ought to have been looked at around closer to the time when they occurred. And for it to arise at this point really is about, and given that there's only evidence from two individuals, we're relying on very, very unreliable evidence, right?
Well, Your Excellency, we would concede that it would have been ideal to look at these violations closer to the time they occurred. But the fact of the matter is, these allegations were not looked at in 1992, 1993, or 1994, and therefore they should be looked at today. This is something that my co-agent will be elaborating on later in his submissions, but our position as the petitioners is that the ACHR and the Bellum do Para both clearly conceive criminal law and criminal prosecution as a method of enforcing human rights. and therefore there is this obligation on the state of Naira to prosecute any alleged violations of both the ACHR and the Convention of Belem Para. Regarding your inquiry specifically into the evidence concerned, we would like to direct Your Excellency's attention to paragraph 33 of the facts, which states that Kila Pura did a thorough investigation that included interviews with neighbours, victims, and witnesses, which does seem to indicate that there is more than just the two key-space testimonies. Rather, there is concrete evidence that this NGO found it necessary to bring a criminal complaint against the state. Would Your Excellency like me to continue with the argument regarding sexual abuse, or?
I leave it to you.
Yes, Your Excellency. We would submit that this act in question is torture, per this court's distinction between torture and cruel, inhuman, and degrading punishment, which per this court in Espinosa Gonzalez is that torture is an aggravated form of inhuman treatment that is perpetrated with a purpose, such as to obtain information or confessions or to inflict punishment. On the facts of the case, Your Excellency, the key space clearly suffered this aggravated and serious extent of psychological trauma. Crucially, even a single instance of rape is severe enough to constitute a crime against humanity under the Rome Statute. In this case, Your Excellency, the key space were young girls of 12 and 15. They were vulnerable detainees completely under the control of the soldiers.
And does it matter whether they were young?
Yes, Your Excellency, we would submit it does matter.
But we're not talking about prevention of arrest of the child, right? So it doesn't matter whether they were young, it's just that they were raped, right? Are you saying that it's much more egregious because they're young? I mean, the fact of the matter is that violations.
Well, Your Excellency, regarding the distinction between torture and cruel and inhuman degrading punishment, this court has put forth that the classification of an act, whether torture or inhuman treatment, is a case-by-case basis that considers...
No, but that's what I'm saying. Irrespective of whether you are 5 or 50, a rape is a rape. It really doesn't matter. So is this where the real fight is? Is this where the real problem arises? Is this something that the Republic of Naira is going to say, it was not torture, it was not cruel, inhuman, or degrading punishment? Because I cannot imagine anyone trying to make those kinds of arguments. I don't know whether you have the memorials, but I cannot imagine that being argued in the memorials either. Is that the issue? How about the cooking and cleaning?
With regards to the cooking and cleaning, Your Excellency, our submission is that this was clearly an act of forced slavery under Article 6 of the ACHR. Per Article 6.2, the key space had a freedom from forced or compulsory labour, which this court in Ituango massacres has defined as involuntary work exacted under the menace of penalty. And in this case, considering the key space were detainees who were being brutally and frequently sexually assaulted.
No, we're not looking at the sexual assault, we're looking at washing, cooking, and cleaning, right? If we look at that, how is it forced or compulsory labour where it is actually, for example, part of the things that are required of people who are actually detained? I mean, it's not very clear here. They're forced to wash, cook, and clean for themselves and other prisoners every day. How is that slavery?
Your Excellency, we concede that the Article 6 right does not actually prohibit imposition of a penalty that includes forced labour on the prisoners.
Well, it's not penalty because they were being investigated, so it's very hard to say that there was a penalty because there hasn't been a trial yet, right?
Yes.
But, I mean, we're talking about them being held under remand, and when you're held under remand, in order to maintain humane conditions, you have to wash yourselves, you have to cook for yourselves, you have to clean for yourselves. Then what's wrong with that? There's no indication here that they were washing, cooking, and cleaning for anyone other than themselves, right? Is there? So if the requirement is that they clean themselves and they wash up on a daily basis and that they cook for themselves, is there a breach? Is there a breach of a human rights obligation there?
Your Excellency, we submit that if it were the case that they were only required to clean up after themselves and wash for themselves, we would still find that there was a human rights violation on the grounds that Article 6.2 and Article 6.3a, the express wording of both the articles are quite strict, that
Well, in contrast, then leaving them in filth and squalor, isn't that also a breach of the right to humane treatment? Right? So we're really talking about, Thank you. Everything's inside. Thank you.
Your Excellency, we submit that if it were the case that they were left in filth and in squalor, that would be an arguable case for a violation of their rights to humane treatment. But even so, Your Excellency, our argument would be that the obligation is on the state to maintain these humane treatments without having to impose this obligation of labour onto the detainees themselves, especially considering they haven't been sentenced, no penalty has been established. The very fact that they've even been detained in the first place, Your Excellency, is already a violation of their rights.
Isn't it recognized in all jurisdictions that when people are being detained for investigation purposes, that there's a permissible period of detention? And in this case, 1 month is actually a lot less than what happens in many jurisdictions.
Your Excellency, we would submit that a period of 1 month is still an excessive period.
Is there an issue relating to the fact of their youth then? In relation to detention for the purposes of investigation given their youth?
Your Excellency, we would submit that regardless of their youth, 1 month would still be an excessive period of detention.
Okay.
And we would make this submission based on 2 reasons. Firstly, that under Article 7.5, which sets forth that the Kispeis have this right to trial within a reasonable period of time, the only, per the Inter-American Court's jurisprudence, the only legitimate purpose of such a pre-trial incarceration would be one that is preventive in nature, in that it is to prevent the accused person from absconding and escaping justice, or to prevent the person from hindering any investigations. So our first submission is, on the facts of the case, there was no need for this precautionary pre-trial detention on the Kispeis because there is no evidence that they would have hindered investigations or would have absconded and escaped justice. But also taking their case in the highest, even if there was evidence of this legitimate justification for pre-trial detention, the duration of 1 month clearly evinces that NAIRA failed to process criminal proceedings with due diligence and promptness.
Well, that's what your court will be dealing with, right?
Your Excellency, that's actually what I intended to deal with.
Okay. Which is Article 8, isn't it?
And Article 7.5, yes.
Okay.
With regards to state practice, while this definition of diligence is not articulated in the ACHR, the UN Human Rights Committee has indicated that detention periods should not exceed a few days, and judicial review should ideally be made available within 48 hours.
It's indicated, but it doesn't necessarily mean that it is actually followed in many jurisdictions, right?
Yes, Your Excellency. However,
what's the state practice in relation to the sort of acceptable period of detention for the purposes of investigation? Is there one?
We would submit that the state practice we should adopt is that of the European Court of Human Rights.
Why European Court? I mean, when we're looking at Europe and very developed countries which have established, judicial investigative systems, as opposed to, a lot of the South American states which are still in a state of some level of, turmoil in terms of their investigative services and all that. Is it a fair comparison?
Well, Your Excellency, we would agree that with a lot of South American states and Latin American states, the standard is not as strict.
Mm-hmm.
For example, Bolivia caps pre-trial detention at 12 months without any indictment, and the Mexican Criminal Code of Procedure caps pre-trial detention also at 1 year.
Yes.
However, it is our position that these state practices do not abide by ACHR standards, in light of the fact that the Organization of American States has released a report in 2017 calling for a reduction in the use of pre-trial detention.
But that actually means then that the practice of states really is that there is a long period of pre-trial detention, and it's not because of anything other than the fact that their systems are really not ready for the rapid period of detention and trial that is in existence in more mature and more stable jurisdictions, right? So doesn't that indicate that the state practice is that it is evolving?
Well, Your Excellency, we would agree that with regards to the rate of development and the rate of processing that that Latin American states
Right.
will be able to cope with, maybe one that does slightly lag behind the European states.
And we're also talking about looking back with 2020 vision, because we're really talking about a time frame between 1992 versus now, right? So talking about what, 26 years ago?
Yes, Your Excellency.
Yeah. So is it fair to judge them with 26-year-old standards? What were the standards in Europe, for example, 26 years ago? The European Convention on Human Rights, I think, wasn't even in existence at the time, was it?
I believe it was, Your Excellency.
So what were the standards then?
Well, the case of Brogan in the United Kingdom was a 1988 case,
Okay.
where the European Court of Human Rights found that even in a state of emergency, where formal derogation of rights had been made pursuant to the fight against terrorism,
Yeah.
so this case was regarding the terrorist attacks from the Irish Republican Army,
Yes.
this period of detention should be less than 4 days in
Okay.
order to ensure that the essence of the detainee's rights are not impaired. So they were
Okay.
referring to the right to freedom from incarceration as well as the right to presumption of innocence.
So that's in relation to the IRA and the United Kingdom, which, to be honest, has not faced any kind of sort of internal political turmoil for quite a long time. So how does that compare then to American states, or Latin American or South American states? I mean, what's the most stable South American state that you know of that has been able to try and achieve that?
Your Excellency, we would concede that even the most stable of South American states, which in our opinion would probably be Brazil, has not been able to achieve such a standard.
Mm-hmm.
However, we would further contend that regardless of whether they are able to achieve such a standard, this is the standard that they've agreed to in signing on to the treaty.
Not really, because in signing on to the treaty terms don't actually impose a specific time frame, right?
No, they don't, Your Excellency.
The treaty, which is the provision again?
Article 7.5.
Yeah, so it's reasonable time, right? And brought promptly before a judge or other officer to exercise judicial power, right? So reasonable time is very, very vague, isn't it?
Your Excellency, we would concede that reasonable time does not refer to a specific time period. However, in light of the fact that a pre-trial detention already infringes on the detainee's rights to a freedom from incarceration and the presumption of innocence, this pre-trial detention reasonable period must be read as strictly as possible. Furthermore, Your Excellency, we would submit that the ACHR should in general be read in a manner that is favourable towards the victim's human rights in question.
What's the relevance of the emergency that was declared?
Your Excellency, the state of emergency was declared in 1990 with regards to the Freedom Brigade's attack on Wami, Kiliki, and Someko. However, our position is that the state of emergency does not excuse the violation of the key space with regards to the reasonable detention period as well. Your Excellency, we would submit that the state of emergency does not excuse the violations for the reason that the state of emergency liberty under Article 27 only allows the petitioners to suspend guarantees of non-derogable rights to the extent strictly required by the exigencies of the situation. And while we acknowledge that extended detention may be necessary during states of emergency, this necessity must also be balanced with protection of the detainee's human rights. And a minimum requirement of this balance, per European Court of Human Rights jurisprudence, is that the state must adduce relevant evidence capable of satisfying the court that the state of emergency rendered judicial intervention impracticable for that duration of the detention. And in this case, Your Excellency, we would submit that NARA has not made any specific allegations with regards to the necessity of the detention for 1 month or provided this court with any concrete evidence. Your Excellency, I see I've run out of time, so if I may be of no further assistance to this court, I conclude my submissions. Thank you.
Thank you. What is the relevance of the Convention of Belém do Pará?
So it's the
Is that yours?
it's actually covers a bit of both. Essentially, it's a convention to eradicate violence against women.
Okay. Oh, alright.
Yeah. I have 2 copies if you want.
What's relevant to all the background? So innocent, right? Look at all these long stories you have nothing to do with anything.